They called her the fraud of the Northern Grid. The woman who built a company on stolen math. That was what the headlines said. That was what the lawyers argued in their press releases. That was what got repeated on the radio while Darren Schultz, 41 years old, maintenance technician at the Kelowna Regional Courthouse, pushed his cart down the marble hallway and tried not to think about his daughter's lunch he had forgotten to pack that morning. He had bigger things to worry about. Everyone did, apparently, except the woman sitting alone at the defendant's table in courtroom 4. Her name was Viveka Andersen, 53 years old, founder and former CEO of ClearPath Energy Systems, a clean technology firm based out of Vancouver that had spent 11 years quietly doing work most people in the industry said couldn't be done. She had developed a load balancing algorithm that reduced transmission losses across high-voltage grids by nearly 18%, the kind of number that made utility companies nervous, because it meant the old way of doing things was no longer the best way of doing things, and there was a lot of money tied up in the old way. The lawsuit had come from a company called Arcturus Infrastructure Holdings. They were based in Calgary. They were large. They had 4 lawyers present in the courtroom that morning, all of them in suits that probably cost more than Darren made in a month. Their claim was simple on paper. ClearPath had built its core algorithm using proprietary modeling data that originated with Arcturus. Viveka Andersen had stolen the foundation of her own company's success. Viveka said she hadn't. Nobody seemed particularly interested in what Viveka said. Darren wasn't supposed to be in that corridor. His usual morning route kept him on the lower level, the administrative hallways, the washrooms near the entrance, but there had been a water leak 2 floors up, and someone had redirected him, and so he found himself outside courtroom 4, when the doors opened and 4 lawyers walked out in a quiet, coordinated line, the way people move when they have already decided something among themselves, and are simply waiting for the paperwork to catch up. He recognized the woman at the table, because he had seen her photograph in the province twice in the past month. Once when the lawsuit was filed. Once when her company's board voted to suspend her pending the outcome. She was sitting with her hands flat on the table in front of her, fingers spread, the way someone sits when they are trying to keep very still and not let the stillness become collapse. The judge, the Honorable Francis Duperret, 62, who had been on the bench for 19 years, and who had the patient, slightly exhausted expression of a man who had seen every kind of human mistake and stopped being surprised by any of them, looked at the empty chairs where the defense team had been. "Miss Andersen," he said, "do you have legal representation present for today's proceedings?" The silence that followed was the kind that fills a room completely, the way water fills a shape. "No," Viveka said, "I don't." What had happened was this: her lawyers had withdrawn that morning. Not because of anything she had done, or failed to do, but because Arcturus's legal team had filed a motion 2 days earlier, citing a conflict of interest involving one of her firm's junior partners, and a prior contract with a subsidiary of Arcturus. The motion had been upheld. Her team had 48 hours to withdraw. The trial date had not been moved. Her request for a continuance had been denied. The details of why the continuance was denied were procedural and dry, and not the kind of thing that made it into radio reports, but the effect was not dry at all. The effect was a woman sitting alone at a table in a federal courtroom, while the opposing team arranged their notes, and the gallery murmured quietly, and the judge looked at her over the top of his reading glasses, with something that might have been sympathy, but was constrained by the limits of what he could actually do. "You are within your rights to represent yourself," Judge Duperret said, "but I want to be very clear that the court cannot provide legal guidance during these proceedings. Do you understand?" "Yes," Viveka said. "I understand." Darren had stopped moving. He told himself later that he didn't know why. He had work to do. He had a list of maintenance tasks that would take him until 2 in the afternoon. And he was already behind because of the water leak. And his daughter Hazel was 8 years old and attended Springdale Elementary, and she would be picked up by his neighbor Greta at 3:15, and he needed to be done by 3. Because Greta had her own life and he had already asked too much of her this week. He had things to do. He had exactly no reason to stand in the doorway of a courtroom, holding a mop. But he didn't move. He had heard something in the way she said yes. A particular quality of stillness that he recognized the way you recognize a song from a long time ago. Not because you remember the title, but because something in your body remembers it before your brain does. He had used that word in exactly that tone once, sitting across from a social worker 18 months after his wife left. Yes, I understand. When you learn to hold the weight of things in a way that doesn't show on your face, there is a specific texture to how you agree to continue. He recognized it. The lead counsel for Arcturus, a man named Gerald Fitch, who had been practicing commercial litigation for 26 years and who wore his confidence the way some men wear expensive cologne, pervasive, slightly too much, rose to begin his opening statement. It was precise. It was thorough. It referenced metadata from file transfers, timestamps on internal documents, a consultant named Adrian Bellows, who would testify that the modeling structure underpinning ClearPath's algorithm bore clear marks of Arcturus's proprietary forecasting architecture. Viveka took notes on a yellow legal pad. Her handwriting was small and careful. When Fitch finished, Judge Duperret looked at her. "Ms. Andersen, do you wish to make an opening statement?" She stood. She was not tall. She had the kind of face that had probably been called handsome rather than pretty for most of her adult life, and she looked like she hadn't slept well in several weeks, which she hadn't. She looked at her notes. Then she set them aside. "I built ClearPath Energy from a kitchen table in North Vancouver," she said, "in 2013. With 2 engineers I had worked with for a decade and a half, a borrowed server and mathematics that I had been working on quietly for 4 years before I ever touched a single piece of data from any other company. What Arcturus is claiming I took from them, I didn't, and I can show this court why. I just need a little time." She sat down. Fitch leaned over to his second chair and said something very quietly. The second chair smiled. Darren watched this from the doorway. He thought about leaving. He thought about the maintenance list. He thought about Hazel, who was 8 years old, and who had started leaving little notes in his jacket pockets, because she said she wanted him to find something nice during the day. He had found one that morning when he reached for his work badge. It said, in her uneven second-grade printing, "Dad is brave." He had no idea what prompted her to write that particular one. He thought about it now. Standing in a doorway he was not supposed to be standing in, watching a woman prepare to argue a federal commercial litigation case by herself, against a team of 4 experienced lawyers, because the system had moved the pieces on the board, in a way that left her with no other option. He stepped inside. The gallery was about a third full. Journalists, mostly. A few people who looked like they might be connected to the case in some peripheral way. A young woman near the back who had been crying quietly, and who Darren would later learn, was Viveka's daughter, Tamsin, 26, who had driven up from Victoria the night before. Darren found a seat near the aisle. He set his cart outside in the hallway. He told himself he would stay for 30 minutes and then go. He stayed for 4 hours. What unfolded over the course of that first day was not what Fitch had planned. This was not immediately obvious. Fitch was skilled, and he moved through his witnesses with the efficiency of someone who had prepared for every eventuality except the one that was sitting 3 rows behind the gallery, railing in a gray work uniform, watching the documents with the quiet intensity of someone who had once, long before he became a courthouse maintenance technician, spent 7 years as a systems analyst for BC Hydro. Darren had left that work when his wife was pregnant with Hazel. The hours were unsustainable, and there were already signs that the marriage was fraying, and he had made the calculations that a different job, more predictable, more physical, less consuming, might hold things together. It hadn't held things together, but it had left him with a particular way of looking at infrastructure data, at load models, at the architecture of systems built to move energy across distance. He understood what Fitch's witness was describing. And something was wrong with it. The consultant, Adrian Bellows, was 60 years old, and had the careful, slightly performative confidence of an expert witness who has done this many times and knows that the most important thing is not to appear uncertain. He described, with the aid of a projected document, the structural similarities between Arcturus's proprietary forecasting model and the algorithmic base of ClearPath's load balancing system. He pointed to 3 specific elements. He used the phrase strikingly similar 4 times. Viveka raised her hand. Judge Duperret allowed her to cross-examine. She stood with her legal pad. "Mr. Bellows," she said, "the document you're using as the comparison baseline, Arcturus's internal model, what is its version date?" Bellows consulted his notes. "The master version is dated March 2019, and the version you're referencing for comparison purposes. Is that the same document?" "It's a certified copy." "By whom?" A small pause. "Arcturus's internal compliance office." Viveka wrote something on her pad. "I see. And when was that certification applied?" Fitch stood.
Objection. Relevance. Ms. Andersen?
The judge said. "The certification date matters, Your Honor, because it tells us when this particular version of the document was confirmed to be accurate. If it was certified after the lawsuit was filed, that's relevant to the chain of custody." Judge Duperret considered this. "I'll allow it." "Mr. Bellows?" Bellows looked at the document. He looked at it for slightly longer than was comfortable. The certification is dated August 2024. The lawsuit had been filed in July 2024. Viveka didn't react visibly. She wrote something on her pad. "One more question, Mr. Bellows. The 3 structural elements you identified as matching between the Arcturus model and ClearPath's algorithm. Are any of those elements present in publicly available grid modeling frameworks published before 2018? Another pause. Longer this time. "Some elements," Bellows said carefully, "may appear in general frameworks. General frameworks available to any engineer doing this kind of work. Potentially." "Thank you," Viveka said. She sat down. In the gallery, Darren exhaled slowly. He had spent the past 2 hours reviewing the case documents that had been submitted as public exhibits, and which the court clerk had made available in a binder at the back of the gallery. He had read them the way he used to read infrastructure reports at BC Hydro. Not looking for what was there, but looking for what was missing. Anomalies in version history, gaps in chain of custody, timestamps that didn't sequence correctly. He found 3 things. At the lunch recess, he did something that surprised even himself. He walked up to the defendant's table before Viveka could leave. "Ms. Andersen," he said. She looked at him, at his uniform, at the courthouse logo on his chest. Her expression was not unkind, but it was the expression of someone who has run out of bandwidth for surprises. "I used to do systems analysis," he said. "Power grid infrastructure. I left that work about 9 years ago, but I still understand how load models are structured and how document version control works in that kind of technical environment. And I've been reading the exhibit binders." A pause. "I found something," he said. 3 things, actually. I don't know if they're useful, but I think they might be." She looked at him for a long moment. "You're the janitor," was it dismissive? It was simply an observation stated plainly. "Maintenance technician," he said. "But yes. What did you find?" He told her. He watched her face change. Not dramatically. She was not a dramatic person. He was already understanding, but in the specific way that a person's face changes when someone hands them the piece they couldn't find. A small internal shift, an alignment. "I'd need to verify these," she said. "I can walk you through the documents." She looked at him for another moment. Then she said, "What's your name?" "Darren Schulze." "Do you have anywhere you need to be this afternoon, Darren?" He thought about his maintenance list. He thought about Greta, who was picking up Hazel at 3:15. He took out his phone and sent Greta a text that said, "Something came up. I'm so sorry, I owe you one." Greta replied in 40 seconds, "She can stay for dinner if you need. Don't apologize." He looked up. "I'm free," he said. What happened over the next 2 hours, in a small conference room that Judge Duperret allowed them to use during the recess, was not a legal education. Darren did not suddenly know things about civil procedure or rules of evidence that he hadn't known before. He knew what he knew, which was grid architecture and version control, and the particular way that technical documents record their own history if you know how to read them. The first thing he had found was a discrepancy in the metadata of Exhibit 14, a file transfer log that Arcturus claimed showed ClearPath accessing a restricted data partition in the spring of 2017. The log showed timestamps that were sequential in the display format, but the underlying file creation data, visible in the exhibit if you knew to look at the raw field, rather than the formatted summary, showed a gap of 11 minutes between two entries that should have been continuous if the transfer had actually occurred as described. 11 minutes was not an error. 11 minutes, in a system logging automated data transfers, was an insertion point. The second was a version history notation buried in Exhibit 22, a technical specification document that Arcturus claimed had been part of their proprietary model since 2016. The notation, in a comment field, referenced a software tool that hadn't been released until late 2018. If the document had genuinely been created in 2016, that reference couldn't exist. The third was the simplest and in some ways the most significant. The consultant's comparison document referenced three specific structural elements as unique to Arcturus's framework, but Darren had found two of those three elements in a publicly available white paper published by the National Renewable Energy Laboratory in 2017, 18 months before Arcturus claimed to have developed them independently. Viveka sat with her legal pad and worked through each of these with the concentrated focus of someone who has been fighting for a long time on inadequate rest and has just been handed something solid to hold on to. The metadata discrepancy, she said. Can I surface this without a technical expert? The raw fields are in the public exhibit, Darren said. You can ask Bellows to open the exhibit file on the courtroom display and navigate to the raw data field. If he refuses or says he can't, that tells the judge something too. She nodded. The software reference, same approach. Ask him what version of the drafting software was used to create the document. If he says he doesn't know, ask Arcturus's counsel to produce the version records. The tool that's referenced didn't exist until Q4 2018. And the white paper, I have the DOI number. It's in the NREL digital archive. Publicly accessible. She wrote it down. Then she put her pen down and looked at him across the table. Why are you doing this? She asked. It was a fair question. He thought about it honestly. I had a situation once, he said, where I was right about something and I couldn't make anyone listen. Not in a courtroom. Just at work. Something I flagged about a grid segment in the Okanagan, a maintenance issue that I thought was being underreported. I wrote it up twice. Nobody responded. 6 months later there was an outage that affected 4,000 households. He paused. Nobody was hurt. But I kept thinking about what would have happened if someone had just taken the time to look at what I was pointing at. Viveka was quiet for a moment. I have a daughter, he added. She's 8. She started leaving notes in my jacket pockets. He stopped. He hadn't meant to say that part. Viveka looked at him. Something shifted in her expression that was different from everything that had come before. Not the shift of a strategist recalibrating, but something softer and more private. My daughter is in the back of the courtroom, she said. Tamsin. She drove up from Victoria last night. She has an exam tomorrow morning and she didn't tell me until an hour ago, because she didn't want me to ask her to leave. Darren didn't say anything. Some things didn't require a response. They went back into the courtroom at 2:15. What followed was not a dramatic reversal of the kind that happens in films, where a single question causes a witness to crumble and confess. Real things are rarely structured that way. What happened instead was methodical and quiet, and for anyone who understood what they were watching, completely devastating. Viveka recalled Bellows to the stand and asked him to navigate to the raw data fields of Exhibit 14. Fitch objected twice. Both objections were overruled when the exhibit was displayed on the courtroom screen, and Bellows scrolled, reluctantly, to the raw metadata field. The 11-minute gap was visible to everyone in the room. Bellows said he couldn't explain it without further analysis. Fitch asked for a recess to consult with his team. Judge Dupere allowed 15 minutes. During those 15 minutes, two of Fitch's 4 lawyers had a conversation near the side door of the courtroom that they clearly believed was quiet enough. It was not. When proceedings resumed, Fitch's lead associate, a woman named Sandra Okafor, who had been second chair, and who Darren had noticed seemed distinctly less comfortable than Fitch throughout the morning, asked to approach. There was a conversation at the bench that lasted 8 minutes. Darren watched Fitch's face during that conversation, and saw the face of a man making calculations. Then the software reference. When Viveka asked Bellows what drafting tool was used to create the specification document in Exhibit 22, Bellows said he would need to check with the document custodian. Viveka asked that the version records be produced. Fitch said they were not immediately available. Judge Dupere said he wanted them by morning. Then the white paper. Viveka read the DOI number into the record. She asked Bellows whether he was familiar with the 2017 NREL publication on transmission efficiency modeling frameworks. He said he was generally familiar with NREL publications. She asked if he had referenced this specific paper in his comparative analysis. He said he didn't believe so. She asked whether 2 of the 3 structural elements he had identified as unique to Arcturus's model appeared in that paper. There was a pause that lasted long enough to feel like its own kind of answer. They may appear in a general form, Bellows said. In a paper published 8 months before ClearPath was incorporated, Viveka said. That is the publication date, yes. Viveka sat down. Judge Dupere looked at the clock. He looked at the documents. He looked at Fitch, who was writing on his notepad with the focused stillness of a man controlling his reaction. We'll recess until 9 o'clock tomorrow morning, the judge said. At which time I want the version records for Exhibit 22 on this bench. I also want a written response from Arcturus counsel regarding the metadata discrepancy in Exhibit 14. Ms. Andersen, you'll have until 8:30 to file any additional materials you wish the court to consider. He paused. I want to say clearly, for the record, that the proceedings today have surfaced questions regarding the evidentiary foundation of this case that will need to be addressed before we proceed to any further stages. This court takes the integrity of the evidentiary record seriously. He stood. Everyone stood. Tamsin was sitting with her hands pressed together between her knees, and her eyes were wet, and she was looking at her mother in the particular way that adult children look at their parents when they see them as people rather than as parents, which is a look that contains admiration and grief in equal measure. Darren collected his binder of notes and walked out into the hallway and sat down on a bench near the water fountain and felt the strange particular exhaustion that comes not from physical labor, but from sustained attention. His back hurt. He was hungry. He had missed all of his afternoon tasks and would need to make up the time. His phone buzzed. A message from Greta. She drew you a picture. A courthouse, I think, or maybe a castle. Hard to tell. She's very proud of it. He sat with his phone for a moment. Then Viveka came out of the courtroom with Tamsin beside her. And Tamsin had her arm around her mother's shoulders. And Viveka looked like someone who had set down something very heavy and was still learning how to stand without it. She stopped when she saw Darren.
Tomorrow morning,
she said. I need to be here at 7 to prepare. Is there any chance? I start at 7, he said. I can come early. She looked at him for a moment. Darren, I want you to know. Whatever happens tomorrow, you didn't have to do this. I know, he said. Why then? Really? He thought about the right way to answer. About the grid segment in the Okanagan and the 4,000 households, and the maintenance report that sat unanswered in an inbox. About Hazel's notes in his jacket pockets. About the particular texture of a word like yes, when it is carrying more weight than it should have to carry alone. Because I could see what you were pointing at, he said. And it seemed like someone should. She nodded. It was the kind of nod that is also something else. What happened over the following 2 days is a matter of public record, accessible in the federal court registry under case number T1847-24. On the second morning, Arcturus's counsel produced the version records for Exhibit 22. The records confirmed that the drafting software referenced in the document had been licensed by Arcturus in November 2018. The document claimed to have been created in January 2016. This was, as Judge Duperret noted in his written ruling, irreconcilable. Further investigation, which happened quickly, because Judge Duperret requested it directly, and because the questions Viveka had raised had made the integrity of the entire evidentiary package suspect, revealed that the file transfer log in Exhibit 14 had been modified after the original system backup from which it was drawn. The 11-minute gap corresponded exactly to the insertion of 3 lines of data that did not appear in the original log file. Arcturus withdrew the lawsuit on the afternoon of the 3rd day. There was no dramatic admission. There was a press release, later that week, citing the company's decision to pursue other avenues in resolving competitive disputes. The lawyers on their team had already moved to other files. Gerald Fitch was not reachable for comment. Viveka Andersen was reinstated to her position at ClearPath Energy Systems within the week. The board's statement was brief and correct, and contained no acknowledgement of how alone she had been in that courtroom on the first morning. She held a small press conference on the steps of the courthouse, which Darren watched from the second-floor window, where he was replacing a fixture that had been on his list for 3 days. Tamsin stood beside her. Viveka said what she needed to say about the importance of evidence and accountability, and the fundamental requirement that the legal process not be weaponized by those with resources against those without. She said it plainly, without drama, the way she said most things. At the end, a reporter asked whether she had received help during the proceedings. She said yes. She said the help had come from an unexpected direction, as help often does when the expected sources have run dry. She said she hoped to be able to acknowledge that properly, and she would. 3 weeks later, ClearPath Energy announced the establishment of the Schultze Anderson Access to Justice Fund, a partnership with a Vancouver legal clinic providing free representation in civil and commercial cases to individuals facing institutional opponents without adequate resources. The name had been Viveka's idea. Darren had tried to talk her out of the first part of it. She had not been persuaded. The clinic opened in October. On the day of the opening, Darren's daughter Hazel wore her good dress and stood in the small lobby, where there were refreshments and photographs and a handful of journalists, and she looked around at everything with the serious, deliberate attention of an 8-year-old taking in something she understands is important, without yet being able to name all the reasons. On the drive home, she fell asleep in the back seat before they reached the highway, the way she always did when the day had been bigger than usual. Darren drove and thought about a morning 3 months earlier, when he had stopped in a hallway he wasn't supposed to be in, holding a mop he had set down and forgotten to pick back up, watching a woman with her hands flat on a table decide, quietly, and without any audience that cared, to continue. He thought about the note he had found that morning in his jacket pocket. "Dad is brave." He hadn't known what she meant when she wrote it. He thought, now, that maybe she hadn't known either. Maybe she had just felt it. The way children sometimes feel the shape of something before the shape has arrived. The highway stretched north through the dark. The mountains were invisible in the evening, but he knew they were there. He had driven this road enough times to know what was there even when he couldn't see it. That seemed, to him, like the right kind of knowledge to carry.